you were giving them image rights to use your face, right? And they will not have to pay. And then that image right went on forever. The first thing is ignorance of the law is not an excuse. Now, those three words, work for hire. What it means is I'm actually admitting that by signing an agreement, anything I design belongs to you. And then suddenly you have to then begin to fight people to get back your IP. You find out that it has the legal rights to your source code.
Tell me more about the team members having legal rights and the building process of these products. Let's take, for instance, you're building a product that is more like an app, right? Now, you've mentioned devs, UI, UX guys, graphics, brand design management.
Yes.
First off, you don't need to get people on your team without signing an agreement, right?
So from the legal angle, I'll say, sign agreement for everything.
Our guest today, George Ayanjompe, is a Nigerian IP and startup lawyer whose work is centered on startups, founders, and creators. And today, he's here to talk about best practices for founders and creators working in the global tech and creative space.
Someone in that company must have dropped their entire shareholder agreement onto ChatGPT, and ChatGPT retained that data, trade with that data, so it's no longer private data anymore. It's now public data. I can't sue them for it. They own it. Imagine if I invested time in that, developed a website on that, built my entire brand on that, and they shut it down. I can't sue them. We have what's called a one-man company. It's a one-person shareholder, one-person director, and it's a company. Even though it's a one-person company, you understand, so as it's below 25 million, you don't pay taxes. You don't remit VAT.
Before we dive into today's conversation, I just want to say this real quick. If you're just finding us, thank you and welcome to the PT Podcast. And if you've been here with us since, thank you for sticking around. My team and I are building the PT Podcast for people like you who want to grow, people like you who want to feel seen, who want to be heard, who want to be stretched. So while you're here, we want you to do just two things that can help move us forward. Subscribe so you don't miss out on contents that actually sharpens and feeds your mind. That's literally the only thing we demand of you, to keep bringing high quality guests to the PT Podcast for every single one of us. And secondly, you want to go ahead and leave a comment right there in the comment section. If you have any thoughts, please put them down there. You do not know who would see them. You do not know who really needs them at this time. And you do not know who you are helping just by leaving a comment. Today's conversation is one of those conversations that you're not only going to hear, you're going to feel it. And we want you to take action by sharing this episode to your network, to different people building different stuffs at different phases of their life. That's the energy that we need to keep bringing high quality guests. And if there's someone in your mind, entrepreneur, founder, builder, whoever it is that you would like us to speak to, please write to us and we'll definitely make that happen. All right, let's dive in real quick to this one. Barrister George, thank you so much for joining us.
Thank you.
I know this is pretty short notice because it's not like we planned this before now, but I'm happy that you could find time to join us on this show. We want to talk about the very important topic that I think I've run them by you as well, starting the legal mistakes that founders make without even knowing it, especially in Nigeria and Africa, generally as a continent. There are lots of mistakes that a lot of us founders, we are even still doing, those things that we don't know that they are wrong, right? So for Nigerian founders that just trying to bring certain ideas to life, legal work sometimes feel like, expensive luxury kind of thing because the money involved in it, considering that they've not raised capital and whatnot. What are some of those silent legal mistakes that you see that founders are making without even realizing that that thing is a mistake to them?
First, I think maybe perhaps it's a very prevalent thing in Nigeria where we don't really realize the importance of the law until when we need the law to protect us itself. That's one thing. So now when it comes to founders and mistakes they're making, now founders, they want to just go build. Exactly. It's let builders the builders. And they also want to just get us have them go build. They don't want to be burdened down with those things, having to sign NDAs, sign different agreements and so on. And they're so interested in building the product, having something to ship. And, it's exciting to see them do their thing. It's almost magical when you see someone explaining code to you, explaining blockchain to you. And, it's very magical. But then in your head, you're like, how do you tell the person that, sorry, you have a legal issue here? How good that sounds. So one thing first is beyond building, looking at your concepts, how would they play out in the regulatory setting? Because yes, there are regulations. And the first thing is ignorance of the law is not an excuse. And I said, I didn't know about that. I didn't know that ignorance of the law is not an excuse. So for instance, if you're going to build and you're going to use foreign data centers to host your web architecture. They're using AWS, so you're using Google Firebase, all that things to, for instance, to host your web application or to host your software. Yeah, cool enough, because you can't build your data center from scratch in Nigeria. It's pretty expensive. But then you need to get advisory on that and ask a lawyer, like, so what is the implication of those things? So that way you understand the regulation, and they tell you that, okay, fine, if you're going to do that, that means you're transferring people's data outside the country, because Superbase, Google Firebase, Amazon Web Services, their data centers are not located in Nigeria, and that means you're transferring Nigerians' data out of Nigeria. So something like having to note that the Nigerian Data Protection Act 2023 itself provides that when you're going to transfer people to Nigeria, you need to get consent from them. You need to be there in the privacy policy that you're signing with them, that you have to disclose that we're sending it out of the country, and we're going to ensure that anywhere it's going to be sent to has equivalent laws like Nigeria to protect your data. Very important thing again, even apart from the regulation or to what to govern your products. Another thing again is something like, okay, who owns the products? First things first, like, okay, yes, you want to build, and then it's very complex. What you have is very complex. And then you say, okay, I want to speed up this process. So you get a team of devs to come in. You have your DevOps, you have everybody, full stack, back end, front end. That's fantastic. It's good. But then you don't sign an agreement with anybody. You just go, hey, this my guy can code, he can do stuff. This my guy can do UI, UX, he can design, it can, and then you have a whole team working on it. And then you go, we have product to ship now, and you're going to demos. Do you own the product? Is it so you might go, yeah, it's my idea. Do you own the product? Can you claim that it's your intellectual property? Then most people go, oh, but it's one thing. The law is another thing. Again, your assets, when it comes to your intangible assets, your intellectual property assets for companies, most tech companies deal with intangibles. So you want to value this company, you're doing evaluation report for your client, where you have to value what's this company worth. Okay, they don't have buildings, they don't have anything, but here they have this fantastic app. You're trying to acquire them so you can get the app. So then what they're going to value is part of that is going to value the intangibles, the app, the code, the source code of that. Do you own that? So how can you lay claim to that? How can you ensure that your logo, your trademarks, all of those things are yours? How can you ensure that it doesn't infringe on someone else's rights itself? So those things are, I think, things that founders don't really pay attention to. I was speaking to someone in the technical system, as what's it called? It's a good acquaintance of mine, and then he called me straight up, and the first thing he said is, George, I don't talk too much. So you know what? I sent you the overview of it. So just read it. You know, when you read it in an hour, I'll call you. So just tell me what to do. And so they don't want to sit down. Tech bros don't want to sit down and talk with you at length. Like having to talk with the tech bro for 15-30 minutes is torture to them. They have to just be in front of the system and build. They want to talk with people who's going to fund. But beyond that, there's the background work that you need to do. That's one thing. So it's not a luxury. It's very much important for you, so that you don't get to that phase where now you have products, the product has gained traction, then you want to sell or you want to exit, and then suddenly you have to then begin to fight people to get back your IP. You have to fight someone to get back your trademark. Those things can be very harrowing for someone. Imagine having to pour blood, sweat, and tears on your product and everything, and you find out that he has the legal rights to your source code.
Tell me more about the team members having legal rights about in the building process of this product. Let's take, for instance, you're building a product that is more like an app, right? Now, you've mentioned devs, UI, UX guys, graphics, brand design management. First off, you don't need to get people on your team without signing an agreement, right?
So from the legal angle, I'll say, sign agreement for everything. Have agreement for everything. Exactly. So that's where your command ties back to your question. Thanks for your question. It's a very, very good way that you started the discussion, because it's natural when it comes to devs and everyone owning the software. So now under the Copyright Act as 2022. So what happens is, if you tell me, hey George, design a logo. I'll say design because actually before coming into law, I used to do pro design actually. Several projects. So it goes design a product and you go, okay, no problem, sure. Design that, and then there's no agreement. You know, actually under Copyright Act, I own that logo.
Even with me paying you?
Yeah, I own the logo. But the fact is, you might want to go to court, have to argue and say, okay, everything, it's not fair for me to say I own the logo. Yes, there's the part where we call equity. Yes, there's the equity part of it, but it's a hassle. Like it's actually a hassle on its own. Like a case in court can last as much as 5-6 years. So it take you 5-6 years, you're going to pay lawyers to get back your logo. That is if the designer decides to pull a fast one on you. You understand? But then to save yourself that hassle, it's good for you to have a standardized set of agreements for sales like this. So when you have people come in to do stuff for you, they still sign an agreement. It's okay, fine, no, but I'm going to pay your money, bro. How much is the logo cost? And then the person gives you a rate card, and it's okay, no problem. You put that amount in the rate card, and then from the rate card into the agreement, and it's okay, sign. And the agreement states that designing the logo for me is work for hire. Now, those three words, work for hire, what it means is I'm actually admitting that by signing the agreement, anything I designed belongs to you. Okay. Anything. So I don't have to go sign transfer agreements or anything of that nature itself. So anything that I design belongs to you.
Can this work for hire agreement? Yeah. Can it be designed by, take for instance, I'm a founder.
Yeah.
Can I just write it up? Does it need to have a legal stamp behind it?
So the thing is, most founders, like you said, can I? Yes, you can. I don't know. Yes, you can. Yes, you can. But now, do you want an agreement or do you want an enforceable agreement? Which one do you want? So can have agreement existing, but then is agreement enforceable?
In court?
Yes, in court. Is it going to hold up in court? That's where, okay, you can have a phone, but then you want a phone that's the quality phone that's going to last. No, you can make the call exactly, but it's not going to be a quality phone. No, that's one thing. So the fact is, you can have agreements, but is it going to be enforceable? That I can't guarantee. But if I sat down with my legal expertise, I understand your situation, I understand where you want to be in the next 5 years, I understand that you want to be in your Series A, Series B, I understand that you want to be doing big things, you want to raise and everything, and you want to exit in the next 5-6 years and go build something else. I understand that. So I know that, okay, fine, the stakes are pretty much high. So when draft agreements are tying the developers, the designers and everything. So everything that they design belongs to you, and that is registered in your name. So it's such that if you're going to choose to sell or so, you don't have to begin to hassle with anybody or haggle with anybody over your rights, over your IP. You understand?
What's the difference between this work for hire agreement and MOU, a memorandum of understanding?
All right. So now it is one thing I see in tech a lot, where you also people say, oh yeah, we signed SLAs, particularly another thing again is service level agreement. We have service level agreement with somebody. Service level agreement. So an MOU in its basic form itself is just we're saying, okay, Thompson, we discussed that during this itself. So we reached an understanding. That's it. It's an MOU, it's a memorandum of understanding. We reached an understanding that, okay, yeah, we're going to do this, we're going to do that. Understanding, mind you, not agreement, understanding. So memorandum of understanding is just saying, we discussed this and we are kind of just putting it down that we discussed this. We've not built onto something solid yet. So, but this is going to be like a framework for future discussions. So MOUs on their own sense are not binding. But then we began to notice over several transaction cycles, we began to notice some kind of alchemy or so, where I would alchemy in some sense where you have people say, oh, this is an MOU. But then the content of the agreement, the content of it is essentially an agreement. So at that point, many a times, what the court does is, if it has to go to court, the court will look at the substance of it. Because sometimes you can say, okay, this is a memorandum of understanding. But when you look at it, you get already committed yourself to terms. You already agreed to do this, agreed to do this, agreed to do that. Now that in itself is an agreement. It can be enforced against a person.
But it was not written.
No, written is written actually. So if it's written, it's signed, and then you agree to certain terms, you agree to do things in that memorandum of understanding. It goes beyond that. But then if a lawyer that has experience in transactional law itself drafts that, you know that the way you draft a memorandum of understanding proper, you don't promise anything. You just say, hey, we discussed this. We have an understanding that we are going to go into this deal in the future. So
thank you for sharing that, because it's really helped. Most of us, we are even in the trap. We are seeing MOUs as a lot of stress to even draft. So okay, this is an understanding that we are coming into. Yeah. Not even to talk of the agreements. In terms of source codes, logos, trademarks, this IP and intellectual properties that these vendors are provided, maybe they are not our team members per se, but how do you walk around protecting these assets as a founder?
Okay.
Someone building stuff.
So it's like I said, somebody but what you do is to ensure that you have 4 fire agreements with them. We've had to advise clients that are providing services for standardized companies, like companies that are what's called multinationals. So what they do is they have like a standard contract for service, standard contract for service itself. So there was one where we're advising a company, and what that company does is the company provides services in the aviation sector, where they're a travel agency. So when it comes to things like so MICE, that's MICE, so meetings, incentive, conferences, and exhibitions. So in essence, if your company wants to book tickets and things like that nature, yes, they do that for you. They handle all the logistics for you and all of that and everything. So you understand. So now they're providing services to these people for that. So they'll be their designated travel partner. And then we saw the terms in the agreements. And then we realized that this is actually their standard agreement for all vendors providing services. No matter what you're providing to them. And there are clauses in there that says, look, anything you develop, anything you design in the course of doing that, or even if you use any intellectual property, they take ownership from that. So what that is
full ownership.
Yeah, full ownership. And then they're going to be able to use it. And then we saw that and we go, hey, slow down. What that sense about it? What I can is providing to you is just services along that. They go, yeah, this is how, but we were able to negotiate that. They were able to negotiate that and have that because this is not applicable to our clients. We don't want our clients to end up losing rights to their own IP because of just
paying them.
Exactly. You're paying them. But so the thing is, but the takeaway from that is same thing too for you as a founder. You don't have to be so I'll say so aggressive in your strategy, but they have those clauses in there that says, look, I know I'm going to maybe Fort Canvas or anyone, you understand, or Printivo to say, design this for me, design that for me. But you came on an agreement and say, okay, this is work for hire. If someone who's going to work on your code, going to debug it or something, put an agreement, they work for hire. So you're not saying you're not going to pay the person. The agreement is agreement that yes, I'm going to pay you. You're an independent contractor. And then in background, that means I'm not employing you. You're just a freelancer at the rest. So yeah, I'm agreeing that we've agreed you're going to do this work for X rated amount. So 100K, 200K thereabouts. Not a problem. But then whatever you develop, it's work for hire. Because I paid for that work. You understand? And you're admitting here that I paid for that work and that's what I'm paying for. So once the person is done, the ownership of that work automatically vests in you. You understand? So that's one thing. So it falls on a copyright and then you can enforce it. So that's the thing, because most people look, I paid the person. Fun fact, it's just like photography. Photography is such that, so now I don't own the IP to whatever was it called, like this video, whatever I'm saying is, I don't own the IP to it.
Despite it's coming from you.
Yeah, I don't own the IP to it because the person behind the camera owns the IP to it.
But I think there should be a balance.
Exactly. Fun fact actually, which you mentioned. So the new Copyright Act, I said the new one because I still say because I knew where we're coming from, where we had the old Copyright Act that was in 70s thereabouts. Exactly. So Copyright Act, when it wasn't, that was invented too, that we had the Copyright Act. So now what the Copyright Act does, it creates a balance. So between photographers and people who are photographed, and same thing for videographers, people that being in the video. Exactly. So back then, there's a case by Nigerian NTA Star TV, thereabouts, where the person's photo was taken, and then she went, no, you can't use my photo and everything. And then they went, you don't own the rights to those photos. So you can't say it's copyright infringement. And the court said, yeah, that's what the law is. It's very sad, but the law is the law. It's very sad. Yes, we understand that you're not happy to use the photo, but the law is the law. You didn't take those photos. Someone else took those photos. A person owns the photos.
Even without their knowledge.
Exactly. So no, with the person's knowledge or without the person's knowledge, the person owns the photos. Exactly. So, but then where the Copyright Act 2022 comes into place, Copyright Act 2022 still admits that the person who took the photo, takes the video, owns it. But what it does, it gives me a license. Me being video, it gives me a license
to use it.
To use it, to post it. You understand? So I can use it, I can repost it without having to, tell him that, hey, I need permission to do that. Prior to this position, I had to take permission from him to use that. They could even sue me for posting my own photos, which is very funny. But now what I can do is, so it tilts more towards a privacy view now, where it says, okay, I have a license, but it still says I'm not the owner. He's the owner. He's the final owner of the work. So it says, but then it gives me a license to, kind of like it rights to say, well, I was in the photo, so I can repost it and I can tell him that please don't post it. So I can restrict his rights now. So that's the beauty of it. Now I can restrict his right and tell him, please, I just took those photos I just maybe made that video for making sake. Don't post the video. Don't post my photos. And I can restrict that. So that's the only thing. But owning it, he owns it. What the Copyright Act 2022 does is, so it creates that balance between the photographer and the subject of the photo, the person being photographed. So it says, I have a license. Now I'm giving a license automatically by the law, not him giving him a license. Now, if I own the photo, I can give you a license. That is permission to use the photo. So I can repost it, I can post it. I can also use that license to tell him, please don't post my work. So, some photographers will say, okay, I took your work, very nice editing, I want to advertise. So most of them say, no, I don't want that. So now, in this current day and age, people can tell the photographers, no, don't put my photo up as advertisement. Yes. And then they can enforce that rights legally. That's that. But guess what? They cannot stop the photographer from selling the photo. So in India, exactly. Because the photographer owns the photo. If you own the photo, can sell the photo.
And this is applicable to other area of creativity as well, aside from photography.
This is only touching on photography. So the law is silent on other things, which is mischievous. So it still retains the old position where every other thing, unless you expressly state, I call dibs on this, like, okay, all right, this belongs to this person. The person who made it owns it, you understand? That's one thing where it's and same thing where also for where you have employees, in essence, too, you also have to ensure that you put in work for hire clauses in their contract, so that you can ensure that you own whatever they develop during your employment, so that they don't begin to, raise those arguments against you. That if it's a freelancer, have a contract of service with the person. So it's a contract for service with the person. So those things those terms are always muddled up. But you can just say an independent contractor agreement. You understand? You just have an independent contractor agreement. So have that with the person, with the freelancer, and ensure that there's a work for hire clause in the agreement. So there's a clause. So they can all be the clauses that, I'm going to design a logo for you. I'm going to design your front end, your UI, UX. Well, that is good. And I will see you're saying you're going to pay depending on services, but ensure that you have a work for hire clause in there so that you own the rights to whatever is developed. And in the future, if you need to sell it, if you need to take ownership of it, you don't have to enter into those hassles. So those things are very important that you take note of them as a founder.
I want to understand the type of agreement that you can draft for people who, first off, you're not entirely promising them an equity in the brand. And some people, you're giving them equity, at least a small amount of it. Some other people, you're not paying them instantaneously. Some people, you have the luxury of accommodation and food day to day, like internet and whatever,
Yeah.
And they're just offering, putting their mind, soul, body to that work and pouring into the idea, especially in the early stage of development. What type of contract, or agreement do you need to put together in that kind of situation?
Okay. All right. So if it's one thing, but before I come into question, I'll come to the issue of, finance. You mentioned that, person started on their own, they have their own money and everything. So I hear this a lot from many early stage founders. We deal a lot with a lot of early stage founders, and it's your joy as a lawyer, startup lawyer, to see someone cross from that stage of bootstrapping into pre-seed, and then seed funding, and then eventually now they're into Series A and they're doing well, and they have something that is stable that can then eventually grow on its own. So most persons look at it that it's very I'll say expensive to get a lawyer. So I'll say it's expensive not to get legal advice, and it's because when you need it, eventually you're gonna have to pay through your nose to hear what you could have actually heard at the earlier stage. Maybe you could have negotiated something yourself. So now I'll say for founders, it's about sharpening your negotiation skills when it comes to this. Now, your lawyer is a businessman like any other person, and then you can negotiate deal with the person. Say, okay, you don't have to pay for every single agreement. So you could negotiate a retainer. Now, retainer agreements, it's a smart way to have your costs on a budget where you go, okay, if I'm going to have you on service on my payroll, not as basically as a staff, but I'm going to have you on payroll, speed dial for a year or for 2 years. How much is that going to cost? Man, yeah, you negotiate that. So if you negotiate that to a fee, what happens is you obviously not for everything. You can pay maybe twice every year. So you know that you're in growth phase, you're trying to gather your resources, then you pay twice every year. So they can, and then they have person on a 2-year retainer. So now for 2 years, this person is going to do it, or you pay maybe annually, as the case may be, or if they break it down across multiple milestones. So that way, you can have a lawyer in the room constantly, not in the room, on the speed dial constantly, that you can always say, okay, I have this issue, I have that issue, or I'm thinking about this, or this is my situation. And the person can always readily give you legal advice before you get into that position where you're like, it's just a contributor. No, just don't worry. We just maybe would cook up something on ChatGPT. You see, and end the and that's where I see a lot of ChatGPT agreement these days. And you just get a call. Hey boss, I got this thing, and they tell you I gonna learn how to work on it, and I got that's ChatGPT. I don't know anyways. So even every necessity, and what do you think about that? I look at it like okay. All right. So, what's your context? And explain to me, like, okay, this doesn't cover it in essence. You need something a little bit more specific to you because context is everything. The same thing for this question too. But you asked in the context, and I said, let me dial back a bit so that we understand that. So that's one thing itself. So you can have that advice because the more you have advice, you're likely not to go astray. To then down to the main issue of the question you ask. Yes, you can have people contributing, not necessarily independent contractors, not necessarily freelancers. Okay, just a friend saying, they are contributing. So cool one. But still, they still own the IP and the product. So if you and copyright is so vast that if I write something, so for instance, I say, okay, George, just write this, and then I come up with something, and I write that. Maybe not. I didn't say it on the podcast, so I just wrote it down. I said, okay, yeah, this I own the copyright in that. I own the copyright. Let's say you're not dictating it to me. I just wrote it and said, okay, yeah, okay, this is a nice quote, and I give that to you. I own the copyright in the quote because I wrote that. That's my original thinking. So that's what this. So you have was, it's just a contributor. They can't just by saying just contributor waive off his rights. So the person contributed line of code, debugged code, edited code, person has contributed a drop of IP to it. So rather than having all those messy stuff itself, just okay, fine. It's going to be serious business. You understand? Yes, we are as friends working on this code. But please just sign this, you understand? So that way, everything that they all do is work for hire. For you. You understand? Yeah. They acknowledge as contributors to your software, and you can maybe acknowledge it. So, for instance, when we see legacy software, back in the day, I told my before I came into law, my background is in pro design. So if you look at Corel X9 back in the day, or you look at Photoshop, like the early ones. So when it's coming up, you'll see the names of the dev team, like as loading up, you see the dev team, like so they acknowledge people, and so it's always thing of pride from people where you say if you load up your Photoshop or you load up your Corel Draw, just look at the names scrolling through your screen, you'll see my names. Or back in the day, then that's Halo. The game, I don't know if you play Halo. Very wonderful game, bro. Very wonderful game. I mean, also a gamer too as well. So then at the end of when you play the game towards the end, you'll see credits of names of people who tested the game, people who worked on the game in beta. So those things, acknowledgements are there. So you can frame it such in a way where you're not being combative. You're not saying, hey, sign an agreement, because it's always very suspicious when someone tells you.
Sign an agreement, yes.
Exactly. Bro, I just want to just help you out with the UI UX. You understand? You can just go so that way, in the future, we can properly acknowledge you, and this is what you worked on, because in the future, when we work on this software, eventually, it's just like Facebook. Now, Zuckerberg's original code, I doubt it can even fish out the original code. I doubt the original code still remains on the Facebook platform, because so maybe I worked on it.
Yeah.
Maybe I worked on that platform and everything. And so his original code might not be there. Whatever his friends did back then in the early days might not be there. But if he says, you know what, for posterity, we are going to honor this person. So let's just have your name on record. Let's just have this thing signed here. So that way we can also have your name on a wall and say you contributed the early development of this. You can have that, and that's a trick. I would say trick. That's a way you can get people to sign this thing. So this agreement, so that way you own the copyrights in the work, because it's very important. It's very much important to ensure that the intellectual property in your company stays in one place. It stays with one person. That should be you, the founder, and the company. should stay with that, so that if there's need to sell to an investor, there's need to bring everybody on board. You don't have to go and start running around and start gathering your IP stack. That is your ownership of you don't have to start doing that. You can just take up and sell, and it's cleaner in that way. It's not messy.
You mentioned something about ChatGPT, right? Now, this is not ChatGPT particularly, a question related to ChatGPT whatsoever, but thinking about the tools, right now there are a lot of AI tools, right, that a lot of founders and startups are using. A lot of applications that call them layer 3s, layer 2s, built on a particular stack and all that, right? So it's easy access, rinse and repeat, right? There is a recent thing I heard about CapCut, retaining the rights to anything you create on their platform, right? You edit using their platform. So I was just going to circle back to know, are there legal traps that are hidden in most of these platforms that we use on a daily basis that you think that we should be paying attention? Because now I'm going to say this, I'm a victim as well of not reading privacy policies, terms of use. I mean, those documents are long.
I know, because we draft them. I've drafted them, so
they're long as documents. I'm like, no.
Blame us. No,
privacy policies and whatnot. So most of us don't get to read them. We just say, I agree.
Yeah,
but I'm working on that right now, because building solutions as well. I've learned that it's important to go through those clauses, read every single line of them. But sometimes you can't help it, because you really need them.
You just want to just sign up. You want to just onboard.
Just get yourself in there and do whatnot. So what are most of the traps that that a lot of users should be looking out for in terms of these platforms that we use to work?
Okay, so if it's one thing, I'll say it's you mentioned the CapCut, mentioned that one's for instance, when it comes to using any platform to work, you have to look at the terms of use. I'd say it's painstaking. It's not, people just go, this is a pain, and then they'll scroll to the bottom and just click, I agree. Yes, give me the software. Let me use the software. But you have to, because then that determines very much who owns what. It might sound like, there was this face software then back then where you could make yourself look older. And it was the rave, and then until a lawyer actually took time and said he wanted to sign up, but he took time to read the entire policy, and then it learned that you were giving them image rights to use your face, right? And they will not have to pay. And then that image rights went on forever. So, those some things, some unimaginable things lock in those clauses. So, for instance, you had Horizon Worlds. That's Facebook, not Facebook. Meta's their VR platform itself, and apparently anything you design on Horizon World belongs to them. Whatever you design on that platform belongs to them, and those things. So you have to ensure that you look at the policies very much as to who owns what. So for instance, ChatGPT if you don't put off don't train with my data, if you don't put off that particular setting, it trains with your data.
What's the setting?
So there's a setting, you go into the settings, and then you can put off, you can turn off the setting where ChatGPT trains your data. So it
trains.
Yeah, exactly. So you can tell it, don't train my data, don't train with my data. So anything I say on this chat, don't train with it. So ChatGPT will note that. But then again, with the nuances of it, you never can really tell. So that's why I tell people that if you don't really want it to fall out there into the hands of a competitor, maybe perhaps it's like one of my professors back then used to say that taught me the rudiments of intellectual property law, IP law. Said it might sound very crude, but said if you are inventing or if you are creating, said shut up till you get it protected. It's very, you want to talk about it, you want to talk about it, but hey, so you get it protected, just keep a lid on it.
Protection as an trademark or what?
Anything at all, basically trademark, not necessarily trademark. So when it comes to things like your software, also you don't want anyone to have early access to it. You don't want it to be leaked. So for instance, right now Apple is suing someone, a content creator, over iOS 26. The range of it's meant to be what's called iOS 19, but they're calling it iOS 26 now or something. They've changed the names. Okay, no problem. But then they're saying that this person collaborated with someone else to get leaks to their iOS 16 liquid glass software. But so this person did not do anything with it. They just wanted to just be one of the first to tell the public what the new Mac OS or iOS looks like. You understand? And Apple said, we took steps to protect that. You got into that. We didn't want it out there, so we're suing you for getting someone to break into an Apple development phone, an Apple dev phone, to get that data itself. But imagine if Apple put it out there. Apple put it on a platform where someone could get it. So this was this week. So that was on Tuesday. I was at the conference. That's the Business of Law conference, where so this a legal counsel at a top fintech company was saying that they were doing a search, like not doing a search, just doing some work on ChatGPT, and then they asked it for something about a shareholder agreement. And ChatGPT generated a shareholder agreement that had the names of a real company, their shareholders, and all of that. And what does that tell you? That tells you that someone in that company must have dropped their entire shareholder agreement onto ChatGPT, and ChatGPT retained that data, traded with that data. So it's no longer private data anymore. It's now public data. So you have to ensure that if you are not certain about the clauses of that, you can run them by a lawyer. Just a person like, you know what? Let me read this and okay, what does their privacy policy say? But it's very important that you know what their privacy policy. Well, not even privacy policy. Privacy policy you can still enforce around online, but particularly the terms of ownership, who owns what. So if you're going to use it as a creative outlet to create stuff, ensure very much that you own it. Now, most times I'll say it might sound very paranoid, but I'll say if you're going to code, do it natively. Now, yes, if you're going to design, when I say natively on your system, let it be contained on your system. So that way you can have the rights to contain what you want to contain on your system. So your original work is start on your system. And if you want to upload it to cloud software, maybe cloud storage, you can do that cloud storage, you understand? But at least you know that you own what you're making. You understand? But then if you are going to maybe just now there are certain platforms where you can use AI to create your logo. You can use AI to now there's one we call vibe coding.
Yeah, vibe coding. Yeah.
Exactly. So vibe coding, you can just give a prompt. I did that for a friend. So a friend of mine started off his law firm. So I'm gonna give you a shout out. Sapio Legal.
Sapio Legal. Oh yeah. Shout out to you.
So and they started with I decided, okay, you know what? I need a website. So on the side of it, like okay, because it can be very geeky at times and the rest. So I set up his email for him and the rest and all that. Actually, there's a side business on that where trying to look at that where actually what's it called? I do personal email instead of them. So I set that up for him and he goes, okay, I think I need a website. So then I went down a rabbit hole, did a deep dive. There are several websites where you can get fantastic
designs and whatnot.
I'm telling you top-notch stuff. I showed him one of the stuff I did. All I was doing was I was just prompting the AI, do this, do that. And I showed it to him. I showed him the demo and he went, oh, this is good. But do I own it?
That's what you asked you.
No, I'm saying no, but do I own it?
Oh, okay.
That's where the question mark lies. I'm not sure about that. You understand? So that's I think that so Silo, that should then yes, that's Silo. So the Silo as by Mozilla. So where you can have a free website. But then if you go look at I always go and look at the terms. Obviously I'm going to look at terms. And the terms, you don't own it. They do. They own it.
So they can decide to take it down whenever they want.
Whenever they want, they can take it down. So that website is just so if they feel like, oh George, yeah, good job, thank you. But I can't sue them for it. They own it. They own it. So that's it. So most people. So imagine if I invested time in that, developed website on that, built my entire brand on that, and they shut it down. Sorry, I can't sue Silo. I can't sue them. That's just how it is. So those little things are things that people have to look at. So if we're going to create your products around someone else's platform or someone else's platform, you understand, it's built on someone else's platform, at least look at the terms. Know whether they own it. Because it's not going to be so nice for you to put blood, sweat, and tears. I mean, I've seen founders who at times, like, it can be very painful. It can be very painful, like, where it's almost like being a lawyer for them is like you're in the trenches with them and stuff. You're side by side with them. You say everything, and then someone else put up with terms of policy, and then just with one clause, they take everything from them.
Especially if it's a brand that is killable.
Exactly. And you should have read this. Why didn't you read this? Why didn't you run it by us? If you are running by us, we might have told you to use a different platform or design natively on your system or something else. Yes, you want to get the best of tools, but read those clauses, because those clauses they are taking or leave it. They don't force you. Actually, they asked you at the beginning, do you agree? So I'd say for founders, it's very important. So that way you don't end up putting your blood, sweat, and tears or something that's not yours. They have top law firms in Lagos where the Lagos government discusses with them and goes, yeah, we understand you guys are some guys. We understand that you guys are all about the money and everything, but can you, out of the goodness of your heart, provide some advice for these early stage startups where they have issues? And then we'll go, okay, no problem. Yeah, we're willing to. And actually, like, send experienced lawyers in there to provide advice. So you can actually take advantage of some of these hubs where they have dedicated legal support, and they say, okay, you go, yes, okay, this people. So you can go to them, and it's that way. And the person, you can kind of, at least to some good extent, say, okay, the community where this lawyer, I can kind of hold this person liable for any advice he gives to me, because you want advice where you can go back to the person and say, he told me this, and it turned out not to be this way. That's why for lawyers, we protect our reputations a lot. In fact, the law does not allow us to register companies, like, to carry on legal business, because the reason why, the law wants you to be as vulnerable as possible. So if you mess it up for the clients can sue you for everything you have and goes, I relied on your advice and I lost it all.
That means I can't give you equity.
No, you can't give me equity. I mean, you can give me equity, but the thing is, I cannot set up my law firm, you understand? So, and set it up as a limited liability company. Exactly. So I cannot set up any law firm, and say it's a limited liability company. You understand? So now in Nigeria, okay, I have to put that in context. In Nigeria, so if it's one thing, if you go to America, you see where it's a different legal setup altogether, where you have some lawyers operating as PCs, personal corporations. So, and that means their liability to some extent is kind of limited or so. But here in Nigeria, we operate on the OG system. When I say the OG system, is the system we inherited from, that is the British, exactly, where as a lawyer, you're deemed to be a person of honor. So if you're going to tell someone that, based on my legal experience, based on my analysis, go left, you should the thinking is that you look at it carefully, and then you know that person should go left. But if you carelessly tell the person go right, and the person goes right, and the person runs into issues, the idea is you should be able to be held liable. That's it itself. So in this instance, I can't set up a law firm. No law firm set up here in Nigeria, and as limited liability company, because limited liability company means you can't go against the people behind the company. So if, for instance, Hero Concepts, if Hero Concept is Hero Concept Limited, and then I signed a contract with Hero Concept Limited to come and do drone photography for an event, and let's say something happens and someone doesn't show up for the Hero Concept, and I go, oh, I'm annoyed, I want to sue Hero Concept, and I sue you. You can say, no, you signed a contract with Hero Concept Limited, not with Thompson. So you can also Thompson. And the court will go, yeah, that's true. Hero Concept is different. Hero Concept Limited is different from Thompson. But for lawyers, no. We will not. You must stay there, so that way you are accountable to your client. So if you sign with your client in the name of your name and the client to provide legal services, you must provide quality legal services, and you must always at every time act in your client's best interests, within the bounds of the law. Though. Within the bounds of the law.
This is very, very helpful, Barrister George. This is very, very helpful. And I'm happy that I'm getting to hear most of these things, because I'm a fan of the law. I don't like most arm of education and whatnot, but I just want to be in a place of high reputation, right?
Yeah.
So I'm trying to ensure that everything I'm doing is within the legal jurisdiction to ensure that you are safe and other people are safe as well.
Yeah, very important.
Now, many people have already made most of these mistakes that you mentioned.
Yeah.
Up to 90% of them, if not 100,
Sadly.
including myself, right? Now, I'm listening to you, and I believe a lot of people as well who are listening to you right now, and they've been operating for close to 2 years, 3 years, 4 years, sometimes 10 years without a legal structure. Let's say give and take 1 to 2 years, right?
Yeah.
Operations without legal structure.
Yeah.
Where should they even start to fix things? Where should they begin the whole process of fixing stuff, so that they don't feel overwhelmed?
Okay, so well, first thing I say, feeling overwhelmed or not feeling overwhelmed, I think it boils down to the lawyer itself, one of the lawyer, and you get this down to an art over time. You get down to an art over time, because sometimes you go, oh, lawyers, you guys say a lot, you guys say so many, but eventually having to deal with clients one-on-one, having to be at that role where over the years, talking about now about 7 years thereabouts now, having to be in the face of the clients constantly, regularly. You understand where the client goes, okay, what's happening? So you kind of at that stage, you're at that stage where you understand that the client has a problem. So you owe the client that duty beyond knowing the law, beyond being a legal expert, to dumb it down for the client, give it kind of simple and basic. This is your situation. This is what you should be doing. You understand? So I'll say firstly, it depends on the lawyer then dealing with list. So this is my situation. Can you just tell me in very simple terms, okay, what am I to do? Okay, what's my situation right now? How bad is it? Then what am I to do? And okay, this is what I'm to do. Okay, then what's it going to cost me? So that's one thing. But I'll say the first things first is to have a meeting, and if they've been running for several years, at least have a consultation meeting with a lawyer, a startup lawyer. You understand? And first things first is, okay, this is my process, this is what I do, this is how it works. Okay. So now what is the ideal legal structure? And then it's for the lawyer to then advise you, okay, this is the best legal setup to protect you. And then again, things such as tax, where I know that, tax, I'm not so big, so why tax? Well, newsflash, we have new set of tax laws. About four tax laws have been signed into law. Those laws will take the effects from January next year. So if you've not sat down with your lawyer to discuss your legal setup and how the tax implications will go, please do that this year. Because the reason why I said the setup that best covers it for taxes, because if you're operating on as a business name, well, yes, under the Companies and Allied Matters Act, that is CAMA 2020, such that it's very simple setup. There's really nothing going on here and there. Simple setup, just your business name. We can use that to open up bank accounts, no problem, and the rest. But then tax, that's one big thing. Now, you're making money at least. As long as it's money, it's money. That's what the government cares about. That's what, not the government, that's what the law says. That's what the law cares about. So now for under the tax law, so under the Nigerian Tax Act as cases, if you are arrested as a business name, that business name does not have any legal protection, in the sense that it's just operating under a nickname. The business name is that nickname, not that's called the business name. That is the business name, the name is for that business. That's it, that's all. But any profit you make, it's personal income. You must declare it. And once you fall outside the taxable threshold, now they have increased the taxable threshold to about 800,000 or so thereabout. So if you're earning above 800,000 naira annually, you have to pay tax. The taxman will be seeing you. So that's one thing. But then for companies, if you are operating under an LLC, limited liability company, so you might look at, that's very complex, because I'll say people say that's complex because they've watched the movies, they've watched the series, and they go, oh, who's that take over this, that, board meetings. It's not that complex. It's not, trust me, it's not complex. Not even
The
that
taxation,
no, when it comes to the setup of a company, it's not complex. It's not complex. Trust me. So you can have under company law right now, we have what we call a one-man company. So I look at, oh yes, it's a one-person shareholder, one-person director, and it's a company. Back then it had to be minimum of 2 people, but now it's one person shareholder, one person director, and it's a company, and it's good to go. You understand? So what that means is you are getting the best of both worlds. You are operating like a business thing, because the business thing can be just one person. Nobody's holding you down on making decisions or anything or the rest. And then you have the protection of being a company. Mean nobody can sue you personally, you have to sue the company. So when it comes to taxes too as well, now different ball game entirely. If you're not earning up to 25 million naira annually, that isn't.
For LLC.
Yes.
Oh, beautiful.
Zero. Like zero. You don't.
Oh, beautiful, but not beautiful.
So you don't pay anything. And then, so now, in fact, the law was further amended such that, before VAT, that's value added tax. So you're not paying it. You had to charge your customers that take the 75%, take that and remit it to the government. And then they go, you know what? Let's not stress you guys. So you guys don't have to also remit VAT too as well. You can keep that. Exactly.
But, okay.
As long as you're earning above 25 million. So once you cross that 25 million threshold, now 30% applies. You must pay 30% to the government. So anything from 25 million down to 100 million, then from 100 million upward, special rules apply. They don't take everything from you. Okay, they just begin to look at additional percentages. It's not like everything itself. We understand. But if you're in your over 100 million threshold, trust me, you're good to go.
You understand some money.
Exactly. You have some buffer. So, but if you are, not many businesses would do 25 million naira annually. Not many businesses. So, but many of them are operating as business names. And if you are doing maybe 20 million naira annually as a business name, sorry, your tax liabilities through the roof. Like, it's through the roof. Some people, like under the current regime, like before the new one comes into place, I'm going to pay as much as up to 18% tax, or maybe another 20%, 20%. You understand? Because they're like, yeah, that's money. That's money. It's range of tens of millions.
Wow.
They're going to pay. But if you were operating as a liability company, even though it's a one-person company, you understand, the tax is below 25 million, there will be taxes. You don't remit VAT.
So much on taxation that
exactly
needs to be covered as well.
So that's one thing. So, but I would say that's the little I'm willing to go, so that way we don't make it complex. But at least the lawyer has to tell you that, okay, you know what? Choose this setup. If you choose this setup is simple for you. So the thing what they're looking at, the balance is simple. It allows you to do what you're doing. It allows you to build in peace, and it protects you both now and in the long term itself. Then, and once you've had the business side registration gotten out of the way, the next thing is you have another meeting again with the lawyer. You understand? You can have all of it in one meeting where you tell the lawyer, look, okay, I've told you what I do now, right? Good. This is what I want to protect. Because, so for instance, for me, what is of interest to me might be different from what is of interest to you. You understand? So for me, in essence, okay, to put it frankly, I like tech. I like tech. I like innovation. So that's one thing. So for me, my ideas are very much important. Like ensuring that what I create, what I develop, or anything I put down idea form, I want to protect it. But that's one thing itself. So my priorities will be different. So that's one thing. So now you have to tell you, look, this in my business, these are my crown jewels. So if you say, look, this cup here, I don't care about this. If this goes, and I'm not bothered. But you see this plate here with this is not negotiable. Like, how can I protect this? So now you've identified this is what is important for you to protect in the business. Now the lawyer can begin to advise you. So something such as you're saying, okay, what is your most prized assets? Let's say you're a tech company. Now you have your software. So your source code, very important. Very important. Then such that okay, your UI UX, the branding and everything, very important for you. And you go, yeah, anything can change, the name can change, all of those things can happen. Like I use a tool that it's a mail tracking tool. And so the name changed, like the branding changed, logo changed, but it's still the same product. They just changed the logo, changed that, but it's still the same product. Still, everything is still what that different, and nothing is different in the way the app operates because it's still the same source code. That's very important. That's very important because if they want to sell, obviously, that's what they're going to sell. So that person goes, this is important. So you have to be able to tell your lawyer, look, this, I want to get this in my life. I don't care what's happening, whether it's epic, come rain or shine. I want to protect this particular thing. And the person would be able to advise you on what else. And what I'm saying, another thing I said, tell the lawyer what you do. Then the lawyer can also tell you that, okay, although you didn't point out protecting these things, here are some other things that I think you should also protect. For instance, the name of the business. It might be very simple. So for instance, you might have a positive thoughts podcast. Then you have PT, like the way it's designed, the way the logo is written and all of that. Yes, it's something, but you might not think too much of it. But I'm sorry, that's itself, it's protectable. It's a trademark. You can trademark it because eventually that becomes a brand icon that stands you out. And then imagine in the future where maybe several years down the line, someone goes, oh, I'm making shirts now that have this particular type of PT logo and everything, exactly in the same carbon copy. And person goes, I'm selling it. And you go, no, don't sell that. And person goes, so do you own it? And he will go, oh, yes, I've been doing this for about 20 years. But then he goes, do you own it? And they go, well, exactly. So can you sue me then? Funny enough, you won't even sue. You won't be able to sue.
Wow.
You understand? You won't be able to sue to enforce a trademark also. You might be able to sue under other grounds, but then your argument will have to be a little bit much more complex, a little bit more technical for you to be able to establish that case. You understand? But it will have been very good if you was going to register that. So your lawyer can help you identify that and say, okay, you know what? Maybe the name, the logo, so the get up, when I say the get up is brand colors, like the way it's what's it called? The way it's set up. So the UI UX of it was those things are part of the brand. So for instance, if you go on Windows, you know it's Windows because there's a setting what's called the way the UI UX is. Now that can be protected. Same thing too for Apple. You go on a Mac, you know it's a Mac. You know because the fonts, the UX, everything down to the website, it's a similar feel across all platforms. Everything, whether it is iPad, iPhone, whether it's the MacBook Pro, everything looks similar. I mean, whereas to geek out with the iOS 26 updates, they say we'll make everything very, very similar, but frankly, it's still very much similar across all platforms.
But then how, what's the best way to protect all these things you mentioned, the brand identity, the products, the company itself, even the people, the intellectual property of people?
Yes. Okay. So now this IP when it comes to when I say intellectual property, IP for short, you understand, is one of the most important assets that when it comes to for founders and tech companies generally, it's one of the most important things because reason why is everything starts off with an idea. Everything starts off with an idea. So, and you might just think, oh, it's nothing, but until you realize how much value is behind it, So AI, for instance, people look at, oh, AI is AI that, that fundamentally AI is a software. Fundamentally, AI is a software. Hosted on the cloud and everything, and then you can access it there. So, but then imagine if you could copy the entire ChatGPT source code. For instance, DeepSeek model is open source.
Yeah, it's open source.
You can copy it
and go create yours.
But they are saying no, we are allowing you
to do that.
But now imagine if someone just suddenly gives you ChatGPT's most advanced model. Here,
you earn money,
and exactly. And imagine ChatGPT doesn't know. And then you just go put your name on it and then exactly. So those are things. But in essence, it's an idea you can't see. People think, oh, do you have something you can see, touch, feel? They feel that's when you have to. No. So one of your most important things are really but the ideas because it starts from the ideas. So now when it comes to your company, first I say the name. The name is important because people are not, I'm not looking at branding, I'm not thinking about branding, I'm not thinking at this, I'm not thinking at that. But look, your name is such that your business name, the company name, the logo, it stands you out. You understand? It stands out. It stands you out from every other business in the sector, in the field. Your business name stands you out. So you have to have those protected, like bare minimum. So if someone else does not come and begin to use that and write off your goodwill.
Yeah, that's what I'm saying.
Exactly.
Like, how do we then?
So one thing you can do is, so for the business name and the logo, trademark. Understand? Registered as a trademark. So if you're registering as a trademark, now what a trademark does is a trademark says, look, this particular name itself, nobody else can use this name or this logo. You understand? But then again, trademark, we have to also know that it's not general, okay? It's not general.
So you have to singly do it.
You have to actually niche it down. It's niched down to this particular thing. So for instance, if you register Positive Thoughts PT podcast, it would be niched down to, so if you don't, you have to pick a particular category for it.
Class, yeah.
So to give you a case, actually happened. This is something real. So where this case of he's not my client, and it's news everywhere, so I can talk about it. This case of Sabinus and Peak. So now, if you notice, there was a time when Sabinus, during his kids, like, something huge.
Something huge,
exactly. Yeah. And then Peak went and they said, oh dear, this is trendy, this is good. You understand? So it's how. Then again, that's an example of how brands can run into issues when you use memes and some things like that, and in the of trying to jump on memes. So yes, they used something huge is coming and dressed, and Sabina Sweat.
Nice one, I got you.
Exactly, and then it's like, it is like, oh, you're sad, and then I made sure it was calculating
the whole movie. Like,
so,
yes.
You know why Sabina was so happy, was so chill, was Sabina had trademarked something huge.
Serious?
Exactly. But however, the twist was now that something huge was trademarked under real estate and some other category. So now what that means is, if you trademark something under a specific category, you must, the trademark law is that you must pick a category where you want that to apply. So for instance, if I pick George, let's say my name, just say my name, okay, George. Okay, I say, okay, Barrister George, for tech lawyer. You understand? I said I want that to be my trademark, Barrister George, tech lawyer. And I go, okay, then I put that under tech. That means if someone registers Barrister George, tech lawyer, under real estate,
they can use it.
They can use it under real estate. I can't challenge them. You understand? So the only way is if I register what's called a defensive trademark. I register it defensively. You're allowed to. So this is where businesses like Coca-Cola, you understand? These guys have the pockets for it. But again, it's not so expensive.
So can you register in different categories or classes?
Yeah.
Like, let's say, for instance, I want to register 1% better every day because that's my mantra, right?
Yeah.
I know it's everywhere. There's 1% better everywhere.
Yeah.
But depending on the class that it's registered under, if I want to register, like, trademark 1% better every day, is it possible for me to do it across all the classes of trademark?
Yes, it is. So now that's allowed under the trademark class. That's what it's called. So but you have to do it. You cannot do it. So we have up to about 42 to 48 classes. You understand? So you're allowed to trademark across the board. So that's where you have in general defensive trademark. You understand? So we call it defensive trademark, such that Coca-Cola does that. Where any country Coca-Cola goes into, Coca-Cola protects its brand jealously, such that across all the classes. So you can't have a law firm and say the Coca-Cola law firm. Nope, you're going to have a letter. Take that down. And they go, and the Coca-Cola tells you, yes, we are registered under legal services. And you're like, yeah, and they're like, they take it seriously. They take that joke. They take that brand seriously. You understand? So, but then again, it takes some resources. It's not, frankly, it doesn't take billions to do this. Like, it doesn't take billions. So most people think, oh, until I have billions. No, it doesn't take billions, actually. So that's why I said, have to discuss with your lawyer, okay, based on the service that the person, how much the person is charging for the services or something. But long run, it's going to pay off. You understand? It's going to be of long run because it's your brand. It's you being able to protect your name. So you can register across all, but you can't speak, out of 48 classes or 42 classes there, but you can't pick 30 and say you register another 30 and the remaining 12 you leave them. If somebody else was to register 1% better under those remaining 12 classes, sorry, you lost out. You understand? But if you registered under everything, your protection is, it's general, it's covered. You understand? That's nothing. But then if you're like, okay, because of resources, because of funds, let's just pick our relevant class. From Sabinus's case, I'll say advice: double check before you register. Double check before you register that. So, for instance, you're actually 1% better right now. Okay, because of your podcasting, you can put that under entertainment and maybe tech because you're in Web3, you are in and in this space. So these are entertainments. You can pick those two categories because they are very much relevant to you. So at least anyone that sees you in the tech ecosystem, in the entertainment space, maybe on social media and the rest, you understand. If they want to go and take that name or they want to use that, they can get them. Hey, okay, take that down. That's my trademark. You understand? Yes, you can do that. You can enforce it against them. So that's one thing. But then that's one thing you can do. So that way you don't register it under the wrong place. For instance, you don't register it under real estate. If you register under real estate and then you're trying to enforce against somebody for using it in under entertainment, under other things or the rest, well, you might not really be able to pursue that trademark claim against them in its entirety. It's quite nuanced also, you understand? Because what trademark is when it comes to trademark infringement, you're trying to say that, look, if you're saying someone copied the trademark or so thereabouts, it's because you're saying this person used my trademark in such a way that it will confuse people in the field that, look, they're affiliated to me. You understand? Such that people will think we're one and the same or so, or they're about to so that kind of thing. But then, they go, okay, you're starting on that real estate, right? So, real estate is different. What we're doing is milk, kind of like, consumer goods and kind of thing. So, those are quite different categories. So, we're not confusing anybody in real estate category regarding this category. That's one thing. So you have to be, so if you're not at that place where you can afford to do a general defensive trademark, carefully pick the categories rightly. So you have to be strategic. Like, okay, my competitors, my imitators, where would they most likely come from? What industries would they most likely come from? So you have to look at, okay, entertainment is one thing. Okay, maybe tech is another thing. What other categories? Maybe fintech, other things, other places where my computers will most likely come from. Let's say those are like 5 categories. You can register your trademark under those 5 categories. Then as time goes on, when there's cash flow, you can expand your trademark footprints eventually such that it's now encompassing to you cover all the classes that you now have a general defensive trademark. So you don't have to pick it. You don't have to take everything at once. You can just do that gradually. Then you have everything all at once. Then at that point, you have a solid ground for protecting your brand everywhere.
This is very helpful. Thank you so much. You've been dishing out a lot of value here already. Quick disclaimer, everyone. We didn't pay Barrister George to be on the PT podcast. He did willingly, and I'm so grateful that he's giving us these insights that are very, very actionable. I've been learning a lot. I've been journaling as well because I'm a student of life and I like, documenting all of these.
Yeah, exactly. We're lifelong learners, and and if it's one thing, I think particularly it applies to law a lot. Where when someone says something that, look, in the way, so when I started my legal practice, I started out as a state prosecutor actually. Mm-hmm. So president means I handle criminal matters. Criminal matters, yeah, for the states, yeah, exactly, yeah.
Wow.
I'd say I did it pretty well. It's full as well.
How did you land as an arbitration practitioner then?
So yeah, in essence, I'd always wanted to because so now the person under which I started out, I'll say starting cutting my teeth when it comes to legal practice is so Professor Chigo. So that's so I'll say my first legal mentor. So it was a lecturer of mine in university. And so very extensive legal background. Licensed to practice in, I think, over 3 jurisdictions as legal, Nigeria, the UK, as England and Wales, and then also the British Virgin Islands, I think the Bahamas and some other handful of countries or so. So that's a lot. So and then he's also an arbitration practitioner too as well. So and I saw that and I went, oh, I also want to have this. I also want to have this too as well. So I began to look at the field, and then reason why is because I for me, my goal is not to be a one-trick pony. So when I say one-trick pony, so some people say, okay, yeah, specialize, but so being a one-trick pony is okay. People just you can do just this one thing, you can do just this one thing, and now the way the world goes,
I mean, that you gotta be
anything can happen, and then you have a total wipeout.
Yeah.
Then that field is gone because I mean, AI is another one. Is the one you want to say. I think AI was built in such a way that it targeted the smartest people on earth, and it said we can do your jobs. It's maybe it was started as a bet maybe in a pub or something. And someone said, I can build a software that can do what all smart people on earth can do. A person said, and the person come back in 3 years and said, here you go. Exactly. So for me, I said, okay, you know what? I want to, as much as possible, be able to have that footprint. So under what I do, dispute resolution is one of the things. So one of the primary things under dispute resolution is litigation, going to courts. You understand? But then the flip side of that is there's a wide range of ways you can resolve a dispute. Arbitration is one of them. So arbitration is where you don't go to court to resolve a dispute. It's where, in essence, you have a private judge or private set of judges, as the case may be, resolve. So they decide the dispute for you. So you're not going to court. Everything that's happening there is confidential. So, for instance, to give the technical system, for instance, so let's say you have a shareholder dispute. So let's say you have an investor dispute. Let's say an investor is saying that, oh, you use their funds when you're not meant to use them, or things like that. You understand? You might, if that goes to court, it can affect your reputation in the tech ecosystem, and people don't want to invest in your business in the future. But arbitration, you can say, you know what? Yeah, you want to slug it out. You want to, no problem. Let's go to arbitration. Everything happens there is confidential. So in arbitration, they can decide that, hey, you were right, you were wrong, and whoever, winner takes all. It's just like going to court, so as a winner takes all. So there's nothing like shake hands in court. So it's something similar, but then it's confidential. So everything can be said there. Whatever happens in the room stays in the room. And that's the benefit of it. So that's why I said, you know what? So this particular thing, I want to go into it. And then that's why, I took the training. And then, so luckily for me, then so I work with a firm that also does arbitration practice so as well. So, and it was good for me. Like I was not only able to get the training, I was also able to use the work. And now part of what I also do is arbitration practice too as well. And I also opportunity to work with an arbitrator. So this firm that arbitrates in disputes. So I'm able to get that knowledge from someone who has been in the field. And okay, so now for me personally, so I can use that when I'm representing clients in arbitrations and say, okay, I think you should arbitrate here. I don't think you should arbitrate here in this case. But not every case is right for arbitration. Not every case is preferred for arbitration. You understand? There are certain cases where I'll say yes, arbitrate. Other cases, but based on that, when there's need to arbitrate, I can then advise a client and say, I can represent your interest in arbitration. I can tell you, okay, this is how it is. So I think for me, that was where I said training came in handy. And what I do and where I work still ties into that nonetheless. And so yeah, that's one.
This definitely makes you the right person for this question I'm going to ask now.
Okay.
Right. We live in a creator economy era where everybody is a creator, right? Some good percentage of people are content creators, right? Now, here's my question. A lot of content creators, influencers, digital marketers, content creators, they are very clueless about intellectual property, IP, and compliance, right?
Yeah.
I'd like you to highlight most of those subtle ways that we are constantly violating the law.
Okay. So if it's one thing, I'd say, for instance, using people's pictures without their consent. Now, under the Copyright Act, I mentioned that under the Copyright Act, now people have a right to say, okay, look, don't use my photo, don't use my recording, or so. Let's say a person shoots live content. I'd say first you need to you need to first get at least permission from people around and say, okay, fine, do you consent to be in this? Or you have a notice that says, I was at the North Jollof Fest. This was, I believe, last year or 2 years ago. And then they had they had the notice board everywhere on the ground saying, you're coming in, you've been here, you are giving us consent to film you and potentially use this on our marketing, and you understand. And so that's when it's such that you see it. You understand? It wasn't like the biggest notice, but the notice was everywhere. So if you came back in the past, they had those pictures. So as you're taking the shoots, I'm very sure the cameraman was told, like, hand your camera set that you get that shoot. So and then they go, yes, my lord, yes, going. I don't know if you watch football where there's what is called VR. So VR,
virtual reality.
End of that is no virtual assistant, so video assistant referee.
Oh yeah, VAR.
Yeah, VAR. And then, so if something happens, so what VAR does, it zooms in and they go, zoom in. And then they go, yes, there. That's the evidence. So if you're going, oh, I didn't tell Nor to use my filters, and they go, yeah, zoom in. Yeah, see the notice? Yeah, it's there, exactly.
Nor, N-O-O-R?
Yes, K-N.
O-K-O-R. No Maggie.
Yeah, no R actually, just the two R's.
Oh, R. That's the no the
yes.
Maggie producer.
Yeah, so the guys, so exactly. So they did that. So that's something so that content creators don't really look at. So you're in it because those things are things so where everyone has a right to data protection. You understand? You can't just say you're shooting content and then you don't seek people's rights. That's a privacy. So, and that was why the Copyright Act came up with that, saying that people can restrict that. Another thing again is where, for instance, they're using people's songs without giving them attribution, or without seeking permission to use people's songs. So some people's videos on YouTube get copyright strikes.
Yeah,
they're like, yeah, you used it the last song with that song. So what happened is, for instance, Instagram started doing this where they will put the name of the song there. You know what it's like? They'll put the name of the song there. It doesn't that they have to bring it up. Because the reason why they want to help you save it from yourself. So that you're like, okay, at least you have the attribution. And not even save you, not even to save you, to also save themselves. Because they're like, he did the thing, but at least we attributed this person's name there, but he was not posted it. So
it's on him.
It's on him. Exactly. And if you notice, so WhatsApp has this feature now where you can add music to your
images.
And if you notice, you can have the entire song. Just a snippet.
30 seconds.
And reason why, not just 30 seconds. And reason why, it's because of a principle under copyright. It's called fair use.
Fair use, yeah.
So fair use is, you can use 18 bits of something. So for instance, the news now, okay, those guys are giving, journalists are giving blankets, like actually under the law, giving blankets license to use. So for instance, if you're going to report on this podcast on the news, you can take this clip and use it on the news. As long as it's used for news purposes, for reporting journalism, you can't tell them that, hey, wrong usage. No. You can't sue them for that. So that falls under fair use. If someone is commenting on this, like let's say commentary, so the person wants to break down your podcast style, the person uses this, that's fair use. If this is being used in a film academy to train students, educational use, that's fair use. But but now aside this, if you use just a smidge, just maybe like a tiny pinch of it, just in passing, not something too large, 30 seconds here, fair use. So what the WhatsApp do? WhatsApp just share it to something very tiny. So just that portion. So that way they safeguard themselves and they also safeguard it as well from, because they didn't want to meet those people to get license for those songs. You understand? So that's one thing. So in essence, those are those things yourself. And then generally also taking out those videos and cutting it to their videos. Like for instance, those sound effects where some things went very viral, some particular memes went viral, and they use it in their videos and the rest. Or things such as using people's trademarks. So certain movies, if you notice, if people are drinking beer, the beer bottle is it's concealed.
Yeah.
Or if you notice some particular movies, the logos are concealed. Exactly. So those things are things, because reason why those people's logos are trademarks. So they'll tell you, look, no, we don't want that. They are actually using our trademark because you're going to sell the movie. or you're going to stream the movie and make profit from that itself. So someone is going to see someone using that in a movie. So they're saying you should get a cut from that. So you're not going to give us a cut from that. Don't use our trademark. So same thing to what most creators, because okay, you're not there yet, producing a movie in the cinemas, you're making money. I'm making money. So if you don't want to kind of get sued for the money you're making, because it takes a lot to produce content. I mean, it takes a lot of heart, a lot of courage, a lot of efforts. So at least take note of those things. So if you don't want to run, you can obscure the trademarks. You understand? Or at best, just look, say it's fair use. You're just using that as a personal effect. You're not putting that out there to infringe on the trademark. You can just have that kind of notice. You understand? Exactly. That kind of helps. So, and then if you're going to use anything from someone else, use it to like a minimal effect. But maybe from another creator, you might want to get their license, or maybe you want to get an approval from them and say, I'm going to use this little clip for your skits. Permission to use that, something like that at least. So those little ways are things that creators can do, because those are little ways that they breach the law that they are not aware about, or they film anywhere and then they breach these particular laws, but they're not aware about those things. But they begin to take those little steps in the common sense. Yes, definitely. Then they can avoid those risks.
So currently, what does the Nigerian law say currently about using popular music, images, memes online and online content? Are we just a bunch of folks breaking the law without even knowing, and hoping that the law doesn't catch up with us sometimes?
So if it's one thing, I'll say the basic one is don't download music from those websites. You understand? Don't go download music off of websites. No, yeah.
Let's not call names.
I mean, yes, let's not call names. That's that. So most people they'll go. There's a friend of mine, the person goes, yeah, this movie has dropped in cinemas, but hey, cinema is there. When the clear version drops, let's know and let's go.
Okay.
Because stream it, okay. No, that streaming services now, at least it's not, you can get, for the cost of one movie ticket, you can get a month's worth of movies. And now YouTube Music is there, Spotify is there, where you don't have to pay. Maybe on Spotify, maybe you will not get the experience of being able to listen to the album from start to finish in the correct order, because Spotify will shuffle. Or maybe if you go to YouTube Music, maybe you might not, you want to go 2-3 songs without hearing.
That's right.
Without hearing on adverts. And you have to wait for it, exactly. But the idea is, by listening to it on the music there, on that particular platform, the creator gets something, at least. Because if you go through some record label contracts, frankly, it's really sad. And these creators put their soul, time, energy that they are all into actually coming up with these beautiful pieces of work itself. If you see what goes into it, it's a whole lot. For instance, give an example of Avicii. This is someone that I love his music, so I might sound biased at this point. And he passed. I think this was 2018 thereabout. Was a very sad one, because I mean his music was, this guy is just fantastic if you listen to his music. And I think this one very famous one was These Nights. These are the nights that never die. Fair use, by the way, fair use.
Yeah.
Okay. Yeah, exactly. So fantastic one. Anyways, and when I read about what happened to him, this guy was always going everywhere for shows and everything. Bottom line, he was always touring and everything and rest, and then he didn't have time to eat. Eventually fell ill, and then so those things affected him, and then yes, he passed. So those people put in time and soul into producing this beautiful piece of work. So at best, don't download off illegal sites. Listen to their work. If you can pay to stream their work, at least it puts some money back in their pockets. And if you can go for their shows, no problem. I mean, I personally, I'm not going to say, but at least I can say, hey, I stream. At least I put some money in the person's pockets. So, yes, so do something like that. At least it's just little ways that you can atone for the illegal downloads and something they passed or so thereabout. Because to give an example, live example, one time, this was when I was in university, Kunle Afolayan, the very famous movie director. So he came to university. Then so we had a session And then so he said he's going to talk to students. And then someone said, oh, 1960. Oh, and the person goes, yeah, that's I think October 1st. And the person goes, yes. I'm sure he said, so did you watch what time did you watch it at? The person said, I watched my laptop. And his face lost color and he went, do you know how much it cost us to rent cameras to shoot that movie? And you went and downloaded it illegally. So this will put in a lot. So you can at least look at their work from the legal sources. You can please do. It helps them. People, when it comes to enforcing, well, because of the fact of that courts in Nigeria, like having to go to court, it can be a hassle. You might not really sue people at like a lot, but in essence, at least, even though they're not suing you, you're hurting them, you're harming them. So please, let's at least, if you want to watch the cinemas, at least you watch it on Netflix, watch it on Amazon, exactly, Amazon Prime or anything on there. But please don't stream the work illegally. Don't download it illegally. At least have mercy on them.
We've covered so much today, and I'm very grateful that you could share all of this piece of information with us. I believe that you've gotten a lot of value from this episode today. If you have questions, you have a lot of things in your mind that you need clarity on, we'll link Barrister George's information in the description. Please reach out to Barrister George, ask your questions, and definitely let him know that you listen to him on the Wheels of Thought podcast. We want you to help us do one thing. Please go ahead, bookmark this video, share with your connections and your community members as well. Because if you're a content creator, you're someone who is creating anything at all, whether you're a founder, investor, entrepreneur, whoever you are, this episode is for you. And we want you to get much value from all of the things that we've said here when you implement, which is what our drive is, that you're able to take an action today. The next thing we want you to do is go ahead and hit the subscribe button down below, because that's one of the fuel that we need to keep on making what we're making and making life beautiful for every one of us. And that's one commitment that we have with you, that will continue to bring high quality guests, high profile people in different industry who have domain niche expertise on certain topics. And we are very much happy to do this together with your support. So see you on the next one. But until then, go ahead and share this video. Don't forget to leave a question in our community channel so that we can know the next thing you have in mind. See you on the next one. Thank you so much, Barrister George, for joining us.